Hey, welcome to what I think is probably the single best panel we have going here today. I know Sunday mornings, typically you'd be watching Meet the Press with world-class journalists talking about the hot political issues. For me, I'd be watching world-class sports reporters talking about the Cubbies or the fact that Penn State beat Ohio State yesterday. So welcome to the cyber lawyers. I don't want to waste any time. I want to get to your questions immediately. This is a heck of a distinguished panel on this, and to sit there and go through introductions would take up a lot of time. They are all, world-class lawyers here. I'm going to point out one thing, and I will only single this out, and that is West Point finally got their hands on Mr. Schmidt here, becoming the Francis Lieber Distinguished Scholar a couple months ago, so thank you and welcome to West Point. At any time, we want to ask...
I was in the Air Force. It's not a good thing.
Now, Air Force Colonel, retired Air Force Colonel, but now on the hands and singled out on this. So ask your questions immediately. We want to address what you want to talk about, and we want the interaction of the issues with the panel. Some of the topics we're going to cover are here in front of you. The rollout of Tallinn 2.0, industry views from Kristen Goodwin and Microsoft on this. Look at how those views are they consistent? Do they conflict between government, academia, and industry? And then you can see the specific topics that we are going to go in there. So kicking us off, looking at this, Lee's the applicability of basically international law in this realm. Could you kick us off with that, please?
Sure. So when we talk about the Tallinn process and applicability of international law, then this really was not a major issue during the 6-7 years that we worked on the Tallinn manual, both Tallinn 1 and Tallinn 2, because the issue of applicability, in other words, does international law apply or not, has always been a political debate. And because our work was academic and not political, we didn't devote too much attention to it. In Tallinn 1, when we did not yet have global consensus among states that, yes, international law applies, we did pay a little bit of special attention to the issue, and we said that, yes, international law applies, and we explained why. But in Tallinn 2, that was basically a given for us. International law applies, and we focused on how it does. And the challenge instead in Tallinn 2 was that we identified lots of international law that applies to state activities in peacetime. There were so many different legal regimes that we basically categorized them into 3. So one was general international law, concepts like sovereignty, jurisdiction, the principle of due diligence, the law of state responsibility. All of that we said applies, and then we looked at how it applies. Then we analyzed a variety of specialized regimes of international law that we concluded were relevant for cyber. These included air law, space law, the law of the sea, international telecommunication law, international human rights law, diplomatic and consular law. So very different, diverse legal regimes that we concluded applied. We looked at how they apply. And then finally, we have a section that's titled International Peace and Security. And there, in terms of peacetime, we looked at the obligation of states to settle their disputes by peaceful means. We looked at the prohibition of intervention, and we looked at how the law governing peace operations applies to cyber operations that are undertaken during peace operations.
So now, Michael and Lise, could you tell us about 2.0, getting to 2.0, and the difference in moving that past 1.0?
Well, the big difference was in Tallinn 1.0, we were just a small group of people. They weren't selected based on geographical distribution or anything. They were just 20 smart people who were brought together to look at the subject of the jus ad bellum, the use of force, and the law of war. When we produced that, it was a success of sorts. So the CCD COE came forward and said, could you expand this in some way? And we thought we would deal with the peacetime regime. Now, because of criticism of Tallinn 1.0, what we did is we internationalized the group. So we have someone from China, for example, someone from Japan, very distinguished scholar from Japan. We have someone from Belarus. And so the group is much more international than the first group. The other difference was in Tallinn 1.0, states held us at arm's length because they were terrified at what we might come up with. They did not want to be bound by anything that a group of 20 academics came up with. So in Tallinn 2.0, it was very different because once states understood that the manual would be referred to by states in their cyber practice, they became heavily involved. The Dutch government approached us, offered to support the state involvement process. It's called the Hague process. We met with states on 3 occasions, over 50 states, including all the P5. Jonathan represented the United States in a non-official dialogue. So this was not the official position of China or Russia or the United States. This was just a discussion about our text. It was very valuable. Jonathan, in particular, I remember, it's non-attribution, but in the law of diplomacy, he identified just a basic mistake we had made that fundamentally changed how we dealt with the law of diplomacy. So the big difference here is this time states were engaged. So there's a lot of state input, both at the 3 meetings held in The Hague and then subsequently thousands of pages of comments from states, much more than Lise and I anticipated. It took us a great deal of time. So Tallinn 2.0 is a little bit different in that sense. I believe that Tallinn 2.0 will be much more important than Tallinn 1.0. The reason is Tallinn 1.0 deals with those malicious cyber activities that are at the upper level, that constitute the commencement of an armed conflict, that constitute a violation of the use of force, that constitute an armed attack such that a state may respond. However, on a day-to-day basis, I mean, as we read the newspaper, we know that the activities that happen almost never reach that level. The activities today are all about sovereignty and non-intervention and other bodies of law, what we call below the threshold. So I anticipate Tallinn 2.0 will be much more important. The manual we produced will include both Tallinn 1 and Tallinn 2. It'll be a single manual. We did take a look at Tallinn 1.0. We had a team of graduate students who surveyed everything that had been written on Tallinn 1.0, and based upon the commentary, a group of 4 of us sat down, made a few changes, and then provided those changes to the original group for acceptance. It's important to understand, since I'm sitting next to Gary Korn, that Tallinn 2.0, the Tallinn manual, is in no way binding whatsoever. It's 20 people, 2 groups of 20, who said, this is what we think the law is. The reason it's valuable is not because of what we think the law is, but because of all the areas where we identified where the law is gray. And so if I'm Colonel Gary Korn sitting there, the useful piece is, as we look at, for example, intervention, the various discussions on what coercion, the element of coercion may mean in intervention, because he's responsible for providing advice to states that will constitute state practice. So I think that's the strength of the manual, the fact that we did not try to answer every question, we tried to identify every question in the law.
And that will be coming out January?
Yeah, if there's a God, yes, January. So, I mean, you've seen Lise and I sitting in the back. The secret is Lise was not taking notes. She was furiously working on the index. It's not collective self-defense. It's self-defense, collective, anticipatory, and so forth. So, yes, the answer to your question is yes, we believe it will be out in January.
Okay, outstanding.
And it will be, but by the way, I should mention, since the director of the CCD is here, we will be launching it at the Atlantic Council on February 8th, I believe. Is that right? You can't remember?
We don't know yet.
We'll be launching it in February at the Atlantic Council.
Outstanding. So you mentioned states being involved. Kristen Goodwin from Microsoft and a world-traveling attorney for dealing with cybersecurity. Industry's view on Tallinn 1 and kind of any prefatory comments on the anticipation of 2.0.
Well, you know, as Microsoft, we always anticipate a next product release, but I have to say, we have not been exposed to the details of 2.0. I hope that it is something that the public sector and the private sector get to comment on broadly. One of the things that just strikes me as very, very different coming from the private sector is that when you look at how technical standards are developed, how the rules of the internet are developed. They're developed in consortia. They're widely debated. They're publicly available. The documents that people create that are then debated are all searchable. And so I'm hoping that what we'll see maybe for 3.0 is that we evolve towards the development of an international legal dialogue that is conducted in the public space, so that the working papers and the analysis is something that become a living process. Just for a quick show of hands, how many people in the room are attorneys before we get all legal? Okay, lawyers, technologists, okay, and then some of you are both, I know that. So one of the things that I find fantastic about the law in international and in cyber is that it's almost mathematical. You know, customary international law is consistent state practice and what's called opinio juris. And so mathematically, it's a whole bunch of states, you know, it's a whole bunch of entities agreeing to an RFP or a standard, and opinio juris, which is our fancy way of saying the experts of our community, the noted jurists and scholars have gotten behind that. And so when we look at cybersecurity and cyber law, we're at the very, very beginning. I think what's so fascinating to me about Tallinn 1.0 is that it captures some of the questions about where we need to go in how we think about cyber warfare, but it doesn't yet reflect the reality that nation states don't yet know, that we struggle every day with the fact that cyber attacks are occurring, and we are not in this plane of war. And underlying all of this is the fact that these nation states that may be attacking each other, that may be engaging in these skirmishes, they're all customers. And so it's not necessarily a conversation about going to battle in somebody's piece of land or going through a municipality and fighting block by block. You're fighting on someone's server, under someone's terms of service, against another customer, and the entire environment is virtualized. And it may be outside the jurisdiction of the countries that are battling each other. And so how we think about the virtualized law is something that I think is many, many years away from where we are today. And so I am very, very optimistic. I think that having these conversations like Tallinn 1 and Tallinn 2 are important because we need to be evolving this dialogue. But I also think this dialogue needs to be put on steroids and be turned into like a rave, because we all need to get much more active and much more involved in the dialogue. And so I'll pause there.
So moving on to kind of that view, so looking at government, academia, and industry's view of this process. Jonathan, Department of State, your interpretation of how the view on this is.
So just to start, I have to give my standard disclaimer that I'm speaking today in my personal capacity, and that the views I express today here don't necessarily represent the views of my office, the Office of the Legal Advisor, the State Department, or the USG more generally. So with that out, I think the Tallinn manuals are going to play a very big role, and I think, as Lise said, the question really is no longer about the applicability. Does international law apply to state behavior in cyberspace? It does, and I even think on the political level we have near universal agreement now. And the debate has moved on to the question of how existing international law applies to state behavior in cyberspace. And I think this is how the Tallinn Manual will be extremely useful in that respect, is that it shows that experts can sit down, take existing principles of international law, and can actually apply them. Now, the results you see expressed in the manuals may be subject to reasonable disagreement, but I think it's an extremely valuable project to simply show that, that it's possible to apply these many well-accepted rules of international law to specific cyber incidents or hypotheticals. I think this is an area in which we don't have enough state practice and states' views on what existing international law requires of them or prohibits. out there. And I think in that respect, it will be a catalyst maybe for many states to offer their own views or to react against the content of the Tallinn Manual. And I think in that way it will be extremely useful as well. There are fora in which states are discussing the applicability of existing international law to their behavior. This includes the UN General Assembly First Committee group of governmental experts, which just kicked off in August, late August, early September. Its most recent session, it has a mandate from the UN General Assembly to study this very topic. But it's not an ideal setting for views to be captured on international law because it is a political group. These are really, these are experts from states, currently 20 states, but there are a handful that have a legal background, but these are not legal experts per se. And so, so those lawyers who support their delegations in that forum often struggle trying to ensure that statements that come out of that group actually are legally accurate. And the consensus reports that the group puts forward are negotiated documents, and they're not capturing anything that reflects that is binding on any of the states. And I think it's just not an ideal forum to set out those views. I think an expert process like the Tallinn project is a really helpful way in which you can gather, legal experts to be able to sit down and think through these issues. But I think it will be important for more states to get their views out. In terms of the manual itself, I think you will find that many international lawyers for states will have a copy of it ultimately on their desk.
Hopefully they have it on the internet.
Or on the internet. But I would offer sort of a caveat to that is a caveat in DoD's Law of War Manual. Up front in the Law of War Manual, it states that this manual is not a substitute for the careful practice of law. And I would say that caveat would apply to these manuals as well. I think it's valuable really to the extent that it offers persuasive reasoning for its conclusions. And I think careful lawyers should keep that in mind.
Outstanding. Now, I want to have Kristen remind me about Microsoft norms they came back with, because I want to tie that back together. But I want to talk to Gary, because you mentioned the Law of War Manual and having it on your desk, and someone interjected on the internet. But of course, in the environment a lot of times we practice in, we got hard copy and it's on our desk. So Gary, your perception on this and the process.
Well, let me first also do my disclaimer and everything Jonathan said, because he said it better than I can. So I'm here in my personal capacity. And I also agree with what he said about the Tallinn Manual and the Tallinn process. I mean, it's phenomenally valuable and important. It is stepped into an area where there is new terrain and little development in this area of the law. But one of the fundamental principles, and I think the Tallinn Group obviously acknowledges, is that international law is made by states, right? And that's a key aspect to this. It is on my desk. It is a point of reference. It brings together the relevant bodies of law, the relevant sources of law, and provides an analysis. It isn't that I, in my advice to my client, will always agree with that analysis or the conclusions drawn therefrom, but it is an extremely valuable resource for me and for those attorneys that work for me. And I think that's true across all the government in advising policymakers. This will be interesting to see how this steps forward. And I think Jonathan pointed out the GGE process is challenging. One of the challenging areas with customary international law, I mean, I think generally the only area where you really see states get together and express consensus on particular issues is in more of the positivist treaty formation process. Generally, you see the state practice in customary international law. Less frequently do you see that accompanied by affirmative statements of opinio juris, which is a statement of, yes, we took an action or refrained from taking an action, and we did that based on a sense of legal obligation. That's harder, and so it becomes challenging to sometimes interpret the state practice over time as to whether those are matters of simply political discretion or choice versus out of legal obligation. But, again, the manual is very important in pushing this discussion forward.
So you mentioned the norms and the recommendations that come out of the GGE, and they are recommendations towards the norms on that they submit to the UN. I know Microsoft has 6 norms that have written a paper on establishing certain norms. How do you see Microsoft getting engaged in the process of advancing norms?
So we've been there. I mean, since 2011, when the London Conference on Cybersecurity brought together a large number of industry and government representatives, but it was really focused on cyber. And just the tone and the perspectives are very, very different from what you read when you read the legalistic approach in the Tallinn manual. And so that London conference on cybersecurity norms begat the Budapest, and then I believe they were in Seoul about 1.5 years ago. And so we continue, along with many, many others in the private sector, to participate in a cybersecurity norms conversation. Now, as an attorney, that term frustrates me because it's not a legal norm per se, but what we are talking about are norms of behavior. And when you look at what types of norms the private sector has been articulating, they're a little bit different. They talk about how states should not target ICT companies to insert vulnerabilities or take actions that would otherwise undermine public trust in products or services. States should have clear principle-based policy for handling product and service vulnerabilities that reflect a strong mandate to report them to vendors rather than to stockpile, buy, sell, or exploit them. States should exercise restraint in developing cyber weapons, and it should ensure that any which are developed are limited, precise, and not reusable. Some would even argue that they're attributable. Fourth, states should commit to non-proliferation activities related to cyber weapons. Fifth, states should limit their engagement in cyber offensive operations to avoid creating a mass event. And sixth, states should assist private sector efforts to detect, contain, respond to, and recover from events in cyberspace. So as we are thinking about what are the cybersecurity priorities that we have today relative to international law and the types of behaviors and activities we see, those are our priorities. Those are the underpinnings of the legal questions that we need to see answered as states wrestle with the fact that they are both benefiting from the gray area and struggling to articulate it.
Lise, your opinion on what we're talking about? And I saw you taking some copious notes there.
My opinion is that I think we had the easier task in the Tallinn process because all the norms that Kristen mentioned, they were either political norms or suggestions for new law, but our mandate or our task was to analyze existing international law. So we didn't have to go into any of what she actually just mentioned. And in this sense, I'm sure the government representatives have a more opinionated view on this. But because we brought this up, to what extent was the private sector involved in the Tallinn process? And Kristen kind of hinted at it that the private sector was not too involved. But there was a reason for this as well, and it is the fact that international law is primarily concerned about state-on-state relations. And therefore, it was more important for us to open up the process to state input as opposed to the private sector input. We did talk to companies a little bit, but the purpose of those talks was to get a better sense of situational awareness. In other words, we wanted to know, to what extent do private companies cooperate with states in the cyber context, because that has international law implications. We wanted to know to what extent might private companies hack back on their own initiative in response to state cyber operations directed against them. So examples like that do have some international implications, and we just wanted to make sure that we, in the Tallinn process, actually address those scenarios that play out in real life.
I was saying, so I'm trying to be a good cross-examiner here and go with comments that I'm hearing. So, and I've got the experts here, so when I'm teaching this in my introductory comments to my students, there's public international law, but then there's a sense of private international law, international contracts, things of that. Interesting point. So, right, public international law, government, states versus states. Kristen, you made some good points about, but you're using my capabilities and my servers. So are we seeing that there's a blurring going on there?
Absolutely. I mean, we can hand out glasses to everybody. It's an incredibly blurry environment because think about it in the context of the cloud. You know, I know the cloud it's referenced at least once in Tallinn 1.0. I would assume at some point you'll need volumes dedicated to this concept because the technology is fast and the law is very, very slow. And so if you can have a nation state conducting an operation against another nation state in a cloud environment where they are exploiting a hypervisor, a virtual machine, and neither country A nor country B are in the same location, and the attack is in country D. It's entirely outside of the sovereign control of any one of the players. And so as we think about what your battle plane is, where the fight occurs, it occurs in a virtual environment outside of I mean, yes, there is a physical jurisdiction, but that physical jurisdiction may have absolutely no connection to the event itself, and it's totally governed by contract. And so if one of our engineers happens to see that this attack may be occurring, it may be a violation of our terms of service, and this cyber operation that's been constructed and executed by a government authority gets turned off because it's a violation of the terms of service. It's a really challenging thing for military commanders to have to think through, which is what would that mean from a planning perspective if you fall victim to a TOU. And so how we look at this, I think there's a tremendous amount of uncertainty, and we're just beginning to think about what that means.
So David mentioned to me on a side note letters of marque, and you'd mentioned hacking back. So I would like to go to Gary and Michael and discuss letters of marque and hacking back that was kind of just brought up. Gentlemen, who wants to go first?
Let me say, before I get to that specifically, I think it's just fascinating. Kristen Eisenschur at UCLA Law School, it's a great article kind of talking about what is the right approach to ultimately the regulation of this thing that we call cyberspace or the internet or whatever term you want to use for the day. And analogizing to the law of the sea and space law and where those analogies hold and where they don't. But there's some fundamentally interesting cross-cutting dynamics and tensions in this space that is so unique. And part of it is this multi-stakeholder approach to regulating the internet, which I think you're alluding to, versus the state's role. But the dynamic that we're seeing is however this sort of spontaneously created domain, as we would call it in the military and in doctrinal terms, states are now fully engaged in this. They've realized it. This is Adam Siegel's book, The Hacked World Order. That we've just entered a whole new paradigm. And so, how we sort of segregate our thinking on how we operate in the domain and the close proximity that you have in a military operation to civilian aspects of the domain, just in the overarching way that we see how to regulate it. There's a lot of interesting dynamics. Now, as to the letters of marque and reprisal, I mean, as a government attorney, that concerns me. Because, and I think as you see in Tallinn, just the fundamental questions of state responsibility, that is certainly a very that's a legal mechanism for empowering private entities to act on behalf of the state, but ultimately that is the responsibility of the state, right? So there's questions about, do you do it? Do you create a legal framework that would allow this? Or is it something that the private sector should be able to take on its own? I mean, these conversations...
Or fight it in court, should we be the recipient of one?
Right. These conversations are out there, but it's ultimately, because of the state responsibility aspects of things that emanate from your territory, there's a challenging question about dragging the nation into a situation that it doesn't want to be dragged into, right? Or dragged into. These are challenging questions, no doubt. But then we don't also necessarily have the full capacity to provide the umbrella of protection that you would hope to see. So that dynamic needs to be drawn out, but I just don't know that mark and reprisal is the right answer.
So we just saw Jester decide to deface a Russian website on that just this past weekend and gave a nice comment there saying, "Hi, this is me, Jester. You can't mess with the United States." So we are seeing this happen, and Sony, open source reported, used Amazon Web Services, I believe out of Japan, to do some hack back when they got hit. So Michael, your thoughts on what we've been discussing here?
So, I mean, I take a very different approach. I think international law is robust. I believe international law is very flexible. I believe international law is ambiguous in a way that's beneficial to addressing new technologies and new situations. The response to a malicious cyber operation is very simple according to public international law. I don't do domestic law. We did not touch domestic law. But in public international law, it's pretty simple. If you're the victim of a cyber attack by a state or that is attributable to a state pursuant to the laws of state responsibility, you may respond using unfriendly measures, but lawful measures. This is known as retorsion. If it doesn't violate, for example, the sovereignty of the other state. If it would violate the sovereignty of the other state, your response, then you have to look to the law of countermeasures. And there's a robust law of countermeasures that tells you how you do that. In the event that the malicious cyber operation affects your essential interest in a way that is grave, it poses a grave and imminent peril to the state, then you can reply pursuant to the plea of necessity. And if the cyber attack constitutes an armed attack as a matter of law under Article 51 of the Charter, then you respond pursuant to the right of self-defense. If a private entity is responding to a cyber attack from your state, you have to ask whether or not the state has authorized the private entity to do so. If the state has in any way authorized the private entity to do so, you look to the law of state responsibility to determine attribution. Can it be attributed to the state? If it is the private actor responding on their own, then much of international law does not apply because, as Lee's very correctly said, international law is about relations between states. In that event, you look to the domestic law of the state where the private entity is located. You look to the domestic law where the consequences manifest. You look to the domestic law of the state of nationality of those involved or of the company involved to find your answer. You must also, and it's on your screen, you must also consider issues of due diligence. In other words, when the private actor was responding, did the state from which the private actor responded have a responsibility to ensure that cyber operations from its territory did not violate the rights of the state into which they were conducted? So, I mean, as I listen to this discussion and every discussion that we go to, everyone is selling international law short. While it is true that there are gray areas that will be resolved only over time through state practice with a combination of opinio juris on the part of states with the help of scholars, because of course the work of scholars is relevant pursuant to the statute of the International Court of Justice, over time that will be resolved. But I believe that everyone is selling international law short. And I believe that in great part, this is done out of policy concerns. So with no offense to the representatives of government here, although I know they're in their personal capacity, what's happening is we're getting things backwards. What you need to do is you start with international law. International law tells you what the boundaries of your operations are. International law tells you what your rights and obligations are. Then, once you understand that, then you lay on top of that all of the policy concerns. In great part, policy concerns should not drive an attorney's estimation of what the law is, except where the law is gray and is in development, and there, policy will drive a state to determine not what's good for it, but what's the appropriate interpretation of that international law norm from the perspective of that state's national interest. And then, as was correctly said, at a certain point, there will be enough state practice and there will be enough opinio juris where we will say the norm has crystallized. The norm is now clear. So I'm here to defend international law. Don't sell it short. We went to one meeting. I mean, it was really ridiculous. I think Jonathan was there and Lee's, where a state stood up and said, we don't believe the law of war, international humanitarian law, the law of armed conflict applies to cyber operations during an armed conflict. To which my brain said, you gotta be kidding me. You have got to be kidding me. That's one of the stupidest things I've heard in the last month. Of course it applies. It applies to all new weapons. Now, when the ambassador was asked, well, why do you have this view? Well, we're very concerned that if we say that IHL applies during an armed conflict, this will justify the use of cyber during an armed conflict. This coming from a state that has a very robust cyber capability, which could be applied during an armed conflict. So I think what we all need to do is, at least those of us who operate in the legal sphere, we all need to step back and say, what's the law? And then talk to the policy folks about gray areas.
I do love international law. Personally, it is something I am a fan of and study and have been fascinated by throughout my legal career. But what is difficult to reconcile against international law is this continued policy towards obfuscation. If governments were truly interested in breaking apart, how do we get to the application of international law? What is the consistent state practice? What is the opinio juris? Then we would all be migrating towards a policy of attribution and identification and articulation of the activity of the nation state. But we are wrestling with the fact that governments do not understand yet what are the metes and bounds of these cyber conflicts. And what does that mean relative to our digital lives? So I think we struggle with the fact that international law does provide a platform, but it is one we are not yet ready to stand on.
I think the legal, certainly the two sitting to my left, understand international law. Gary has one issue that he misunderstands. So we've been together. But I believe they understand international law. But I'm with you. States lack courage in this realm to expressly say what they believe, even the most basic concepts of international law are. I mean, to say that Article 51, the law of self-defense, applies to cyber operations is hardly a juridical epiphany. It's hardly. So I think states need to step forward and make clear their views. I agree with you absolutely. But the law is complex, but it's not as difficult as we are making it, as we make it out to be.
And we were talking about that because Charlie Dunlap, the Deputy Judge Advocate General of the Air Force, wrote that. He said, and I've kind of always said this too, the law is there. It's the lawyer's job to do the heavy lifting and apply it to the facts. Christopher Painter's been out there making comments on behalf of state of how this applies. You've got Lisa Monaco, who put the cyber triad out there. And I always talk about kind of our cyber Monroe doctrine, which is what are those standards that we are allowed to respond when we're looking at an armed attack, loss of life, destruction of property. We've seen a new one added to this, the long-lasting economic damage. So as far as what we're saying, is the government stepping forward and making these comments? What's your view on how we're doing as a state to actually establish these things?
Well, so yeah, let me just say that I think I almost wholeheartedly agree with about 98% of what Mike Schmidt said. And as a government lawyer, we apply international law to considering problems that the United States faces and considering the activities of other states on a daily basis. Mm-hmm. And for about 95% of the time, we don't struggle with the outcome and reaching conclusions. Now, there are some very difficult areas, which are the unsettled areas, where we have a lot of discussion within the government, and that a lot of states are grappling with. But I'd say for most of it, it's not, it is a framework that we lawyers know well, that we apply to non-cyber activities all the time, and cyber, except for in a handful of really difficult areas, really it is not as challenging as it's made out to be. I do think that the question of thresholds in certain circumstances is a question that can be challenging. These determinations that we're going to make as government lawyers about specific cyber events or proposals that are brought to us, we're going to have to address like lawyers on a case-by-case basis. It's extremely fact-dependent and context-dependent, and that would include determinations about whether a particular event rises to the level of a use of force or an armed attack as a matter of the jus ad bellum. I think there are other threshold areas outside of the use of force and outside of the context of armed conflict that are also difficult questions, ones that are unsettled. And while we do have a framework of responses that international law provides to states, there are some questions about when certain responses are triggered. Countermeasures is one example. A predicate to taking countermeasures is that you have to have an internationally wrongful act of another state. So then the question is, well, what bucket of internationally wrongful acts would trigger the right to take countermeasures as a threshold matter? Now, we can agree that there are a number that may be easier to decide. If you determine that a state has acted in a way that is a prohibited intervention, you have a right to take countermeasures subject to all these substantive and procedural requirements of that doctrine. But with respect to other things, such as a purported obligation of due diligence, or what it means to violate the sovereignty of a state, and what threshold that might be if you take that view, I think those are unsettled questions. And so I think there are these areas that can be challenging, and there will be differences in views. But I agree with Mike Schmidt that for the large majority of the international legal framework that we apply, it's not as challenging as it's made out to be.
And yet nation states are not taking that to court. We're seeing plenty of attacks all the time, and yet we're not seeing nation states saying, let's go apply these laws and start to develop legal precedent.
Well, I think you have to distinguish between taking things to court and applying the law. We apply the law on a day-to-day basis all the time, but states are not necessarily going to choose to bring a case before the ICJ against another state. I mean, but that doesn't mean that law is not being applied and complied with. So I think you just have to be very careful to distinguish between the idea that you have some sort of adjudicative mechanism, and that unless we see cases brought, that international law is not being applied. I think we have to be very careful about that conclusion.
Right, but I mean, part of that, this goes back to what I said earlier. I think that the challenge is in the majority of those cases, and this is always a challenging dynamic about how much you reveal about your inner thought processes and why you're doing things. And I absolutely, we work closely together, right? We put a lot of rigor into analyzing these questions and applying international law and using the international law framework to do so. But in terms of the development of customary international law, there's a fair argument as to whether or not the government could be more open about what its position is and why it's taking certain actions. But I also, I agree very much with Mike as well. However, it's not just the threshold questions. What Tallinn did, laudably, but Tallinn he didn't look at cyber international law. It looked at international law and how it applies to cyber, sensically, right? But
I think it's correctly.
Sensically. I heard you mention a big mistake, but we'll leave that.
We'll get to that.
But the point is that these are concepts that were developed for different problem sets in different ages. And so it's not just threshold questions, which are very challenging, but there are gaps and seams, I would say, in the overall international law architecture that we're trying to apply to a very new technology. And when you add that in, so those are creating gray areas, and when you're advising in gray areas, there are additional dynamics in this space, not necessarily unique, but I would say uniquely challenging, where this interface with the public sector and your broader policy questions about how do we want to approach this thing called cyber, how do we want to approach it from a broader regulatory perspective, as opposed to treating it like, say, space, where it was fairly simple for the 2 or 3 countries that had game in space to treat it very much like a state question, and develop positive treaty law to govern space. It's a different dynamic. It raises a lot more challenges.
So it's interesting, that transparency part, which sometimes is a challenge for government. And having been, working at the lower Army Cyber Command, then calling up the phone, talking to Gary, I will point out, finding where these legal reviews are happening and getting out there. Again, these are the experts, but Stephen Preston, who's the general counsel for CIA, spoke at Harvard, and he talks about the legal reviews that are done there. that they're confirming that it's under the Article 2 power of the Constitution as the chief executive and commander-in-chief, and it's not just a one-time check. So what they do, I want to applaud. There is a lot of intellectual rigor and legal rigor going into this. I've sat here and tried to be patient on this one, but now I got to go. So, Michael and Gary, there's something apparently you disagree on. What is that? You both referenced it, so I'm going to go there.
I can't remember. Maybe you should go first, Gary, to remind me.
Well, so there's a question. When we talk about, you mentioned violations of sovereignty. I think part of the question is what does that mean to violate sovereignty, and what certain actions from a threshold perspective would constitute those violations. And there are differing views as to, in a sense, whether sovereignty is a rule of international law itself, such that violation of sovereignty would constitute a breach of an international obligation, or if it is more something of akin to the legal personality of the state, a general principle upon which states come together, consent to, and develop prescribed norms of behavior for states, right? Develop international law and the actual rules of international law. So a clear example, not in dispute, is the question of at least a violation of a use of force under Article 2.4 of the Charter. Leaving aside the questions of the gap or lack thereof between Article 2.4 and Article 51 armed attack, different states have different views on that question. But certainly, actions that most would agree would rise to the level of a use of force, whether it's through cyber or other means, would be considered a violation of international law based on the fundamental principle of sovereignty. You'd be violating the sovereignty of a state by conducting that unlawful use of force. Below that, we know of the principle of non-intervention, and that's not controversial. The question is, at that point, is there still a broader rule that sovereignty constitutes? There are reasonable views on both sides of that. It's the references to sovereignty can often be sort of general in both literature and some of the few cases out there in the ICJ that have addressed some of these questions. But I don't want to speak for Tallinn. I think I know where Tallinn sees this. My personal view is that sovereignty is more of that general principle concept, and that is, to me, fundamentally consistent with the core notion of sovereignty, which is the sovereign equality of states and the power only of the state to create international law. So unless you see that evidence that the states have agreed to, either through positive treaty law or the customary international law of an actual rule, then it's a permissive environment. For right, wrong, or indifferent, but that's the nature of international law. So Mike can now tell me why I'm thoroughly wrong.
Well, before I start, Gary is perhaps the smartest lawyer in uniform, certainly among the top 2 or 3. So I don't want to dismiss your view in its entirety.
So he gets a top block on his OER.
Sovereignty is one of the fundamental principles of the international legal regime. Gary's exactly right that it is a foundational principle from which other rules of international law emanate, like jurisdiction, like the prohibition on intervention, like, as the court in Nicaragua said, like the use of force, like immunities. There's no question that these are rules and principles that emanate from the notion of sovereignty. However, I believe sovereignty is a primary norm in and of itself. And what I'm saying is that a cyber operation of a particular nature can be an internationally wrongful act, that's the legal term, in the event it breaches the sovereignty of the state into which it is conducted. I believe that this has been well recognized since I'm a law professor, since at least the 1928 arbitration between the United States and Netherlands over the island of Palmas. It is state practice on a regular basis for a period now measured in many decades. States have stated that another state has conducted an operation that violates its sovereignty. There's plenty of state practice and plenty of opinio juris, in my view, to demonstrate that this is a norm which is clearly crystallized. So my point is, a cyber operation may violate sovereignty. Now we get to the hard piece, okay? The hard piece is, when does a cyber operation violate the sovereignty of a state? The first thing you look at is the intensity and the nature of the operation. Within the Tallinn group, every member of the group agreed that any time a cyber operation causes damage or injures someone in another state, state conducted in another state, or attributable to another state, non-state actor acts on behalf of another state, that's a breach of sovereignty. Moreover, the group agreed that if a cyber operation interferes with the functionality of cyber infrastructure in another state, then in a serious way, requiring repair, that is a breach of sovereignty. The hard work comes in at all those operations that are below those levels. For example, if a cyber operation causes cyber infrastructure to work in a way it was not meant to work, is that a breach of sovereignty? I think so, but not everyone in the group agreed. If you implant malware that does nothing but monitors, is that a breach of sovereignty? Some people said yes. I'm not so sure about that one. Exfiltrate data, alter data. Again, the group was split. So this is what Jonathan and Gary were talking about. In our group, there was consensus that there's a primary norm called sovereignty, and a state may breach it either through its own actions or the actions of non-state actors that are under that state's effective control. We just didn't know where to draw the threshold. There is a second circumstance in which we all agreed that sovereignty can be breached, and this is when another state interferes with the inherently governmental functions of a state. So if one state interferes with, I'm going to make this one up, the elections in another state, elections, democracy, that's an inherently governmental function. Now, we can debate over, exactly when it's interference. We can debate over that, but that's a firm rule. So again, in my mind, the rules are clear. On the broad level, there is a violation of sovereignty. It's either by intensity or it's by interfering with an inherently governmental function. Where we need to devote our efforts to identifying exactly when, where that threshold lies. And we won't know that threshold. That threshold will not be discovered by academics. The threshold is discovered by states. State practice, and there's been a lot of talk about state practice. The problem is in the cyber realm, you don't know what the state practice is, and opinio juris. Remember what's happening here. We are interpreting a norm. So you don't actually have to see state practice to interpret the norm. What you must get is the agreement of states as to the application of that norm. So long as states are making statements about what the law is, that's good enough.
Yeah, I don't think it is, because we still have the challenge of the fact that even if you disagree on how you interpret sovereignty, it's still a breach of contract. And so, the nation states have contracted for these services, and what's happening is that private sector entities are being put in the terrible position of having to make decisions about conflicts of law, not just between 1 or 2 states, but between 30 or 40. And you're seeing that playing out in the courts right now in some of the law enforcement space. And so the thought that we have time to sort of evolve how we think about sovereignty does not reflect the reality of the fact that our future digital life is being built right now in the cloud, in data centers around the world, and conflict of laws, domestic laws, is making it incredibly difficult to be able to articulate a common vision of sovereignty, because right now you do not have agreements among nation states. You don't even have agreement amongst panelists. And so until you get to that point, the one constant is that all of those services are governed by a contract, and that contract is subject to the jurisdiction of a country, and that the laws of that state will be applied, regardless of the fact that there may be this sovereign nation-state battle being waged on top of that. And so I think how contract law is now sitting underneath all of these discussions is a really important element.
It creates, so you can sit down.
I'm done. This is great.
Contract law is certainly relevant to what you can and cannot do. Conflict of law is certainly relevant to what you as a state can and cannot do. But contract law is domestic law, and that has absolutely nothing to do with a state's rights and obligations. The fact that a state may not be able to do something that it is obligated to do as a matter of international law, in other words, that domestic law stands in the way, never is a get-out-of-jail-free card for a state.
But states have to develop those domestic laws.
Absolutely right. But we're talking about state sovereignty, and domestic law has absolutely nothing to do with state sovereignty.
So I would agree with Mike in the sense that an uncontroversial part of sovereignty is the jurisdiction of the state over its sovereign territory and prerogatives. And so I think we are talking about different issues here. So but it is interesting, again, to see the cross-cutting pressures in this very cramped space of cyber, right? So whether or not, in order to continue to progress commercially in this space, we need agreement across states to flatten and standardize the contract norms that each state will apply in its internal laws. That's a phenomenal question. We've seen this in the law enforcement space, right, to some degree with Budapest. So, but again, that is, each state has the sovereign right to make its laws governing contracts. That may create difficulties from an international business perspective, but it is a separate and distinct question from public international law dealing with what states can do vis-a-vis other states in their dealings, right?
Yeah, I don't want to minimize the domestic legal regimes at all. In fact, we addressed the issue of jurisdiction in great depth. What I'm saying is we need to be very careful as lawyers that we distinguish between legal regimes and understand the effect of international law on the domestic legal regime, because that's very, very important as well, and domestic law on the international legal regime. And with regard to domestic law on the international legal regime, there's not a lot of impact. There's not a lot of impact. We dealt with this, for example, in due diligence, and asked the question, if a state has an obligation to police its territory to ensure that harmful activities don't emanate from its territory, what if the reason they can't do that is because there's domestic law that says the state may not do that? And so I went to the University of Texas. We have a doctrine we use there. It's called the tough noogie doctrine. The answer to the question is tough noogie for the state. The fact that you've chosen to impose constraints on yourself through constitutional law or whatever, criminal law, is neither here nor there with respect to your legal obligations under international law. So all I'm saying, the problem that you cite is a huge problem, but it's not a public international law problem. It's a domestic international law problem that can, as Gary absolutely correctly said, could, through policy, you could move into a treaty regime like has happened in law enforcement to create some balance. But that's the only public international law relevance.
But my challenges are mitigated by a stronger enforcement and interpretation of customary and broader international law, which is incredibly slow to occur. We don't see nation states enforcing the fact that cyber operations are coming and having extraterritorial effects and impacting private sector entities and harming citizens. And one of the Tallinn rules that I was particularly fond of talks about the importance of protecting cultural property. People are taking down Facebook and Twitter. That's cultural property of the next generation. And yet it happens all the time. It is. It absolutely is. And so as we
need to be good lawyers. It's not cultural property as contemplated in international humanitarian law.
That will evolve. Wait for the young. And so as we think about how
I concede this point.
How we are going to help protect the economic investment and economic stability of the United States and other nations, we have to have a stronger actual interpretation and enforcement of international law, which is not happening. States are not yet publicly holding each other accountable. Many private dialogues, much private counsel, absolutely.
Well, there's a predictability part of that is important, if nothing else, right? I would say for me to think business-wise, but I would suspect no different than the predictability of contracts and having a solid contract regime, right? But part of this depends on how states ultimately interpret this. I mean, I think in a nirvana situation, we could impose a very, very robust international legal regime that essentially drives states out of cyber from using it as a means and method of statecraft.
Yeah.
Right? I don't think that's reality.
Oh.
And I think that ship has sailed. And we were talking earlier just on this notion of sovereignty or where you set thresholds. It's challenging. You can set the threshold very low, so to speak, but I think the reality, you're going to see persistent non-compliance, you're going to see persistent malicious activity anyway, and that drives its own challenges from an international law perspective. If you drive it higher, now you're treating many more things as in the realm of retortion and counter-retortion, which in itself may encourage continued use of cyber as a means and method of state maneuvering against each other, which in this very cramped space that is riding on the backbone of a commercial enterprise creates additional challenges, right?
Oh, I would add to that, though, that I do have some sympathy for Kristen's concern, because although we certainly did not sell international law short in the Tallinn process, we did identify some very precise areas where I would say international law today is insufficient to meet not just state concerns, but also private sector concerns. And these primarily relate to those cyber assets that have got global use and value, like the SWIFT system, like the DNS servers, like the GPS, and for that matter, perhaps like Microsoft assets. Mm-hmm. Because if we take a cyber operation against a DNS server, we know most of them are located here in the US, so US sovereignty protects those servers, but such an attack would have global consequences, and so states other than the US would actually not have effective recourse to international law and its remedies.
So my fun part that I keep rubbing her with, some of those servers are actually in Dublin, and DOJ is going to say, hey, let's go back and revisit that issue. Chris, you had a question, so if I can get a microphone to Chris here real quickly. He's got an innocent passage question, so if on that, so I'd like you to raise that.
Yeah, so I'll start talking. Sorry. Again, Chris Cleary. I love this conversation. I'm a Tallinn Manual fanboy. It is my Catcher in the Rye. It sits on my desk. I can't wait for the new one. I've already pre-ordered it. I'm a little upset about the $116 it's going to cost me.
Someone tweet that, Tallinn Manual fanboy.
Yeah,
that's got to go out.
Yeah. I love it. And as a guy who has conducted military operations as a reservist at US Cybercom, as a guy who's worked for a rather large telecommunications company, who now works for a security company, it brings up an interesting question. Some of these questions have already been addressed on the stage. Things like, I'm a commercial provider, there are use policies, I don't necessarily want to open up my infrastructure to the ability that you're going to deliver an attack, I become the enabler for all that. So there's questions like, how does the military operate with things like innocent passage? You know, how do I conduct military operations on networks as a naval officer? Things like, hey, I do innocent passage. I can't irradiate, offensive weapon systems as I'm innocently passing through waters. But the other one that I wanted to bring up that I think is interesting for this is, as a commercial company, I like using Sony as an example because I believe companies like Baltimore Gas and Electric and a telecommunication provider would have a reasonable expectation that their technology would be seen as dual-use technology. So in the event of hostilities, I could be a legitimate target for nation states to disable or degrade the ability for, let's say, the US government or the US military to conduct its cyber operations. So carrying that one step forward, I also like the definition of a cyber attack. A cyber attack is something that has a reasonable expectation to cause death or injury to a person or harm, destruction or something to a physical object. So if we go all the way to the end state, and now I have seen myself in that lens, and I am, under the definition of a cyber attack, seen as a dual-use piece of technology in the United States, now I go start looking for the ability to recover losses. Do insurance companies now come in and say, well, wait a minute, now we're talking about force majeure. You were attacked by a nation state. We don't cover that. We're not going to protect you. For the same reason, if a JDAM dropped through my roof by a Chinese fighter plane, USAA Insurance would come in and say, hey, sorry, man, that was an act of war. None of your property has been covered. So as we start going down this slippery slope, as we begin to crystallize the norms and things like attacks have been standardized, Now commercial companies are saying, well, wait a minute, I'm in the crosshairs of a nation state. I have no reasonable expectation to be able to protect myself from those level of attacks. Hey, U.S. government, if you're going to use my equipment in a dual-use capacity, what are you doing to protect my business, my equipment, so on and so on and so on?
Well,
Go ahead, Gary.
I don't know that this area is such a novel question. Oshkosh has the same problem in the production of military vehicles, right? And we need to distinguish between the question of attack in the ad bellum sense that we're referring to here, and that the question of attack in the in bello, the rules governing the conduct of warfare, which is what you're really talking about. What items can lawfully be attacked? That's fairly set, I think, and there are some questions about what cyber activities would rise to the level of an attack for purposes of the targeting rules of the law of war. But the risk is always there for any commercial entity that is providing support to the military operations of the state. There's a risk inherent in that that you could be considered by the adversary to be targetable.
Should Sony Pictures have been considered because they made a movie that might the North Koreans consider a propaganda film?
They're not at war.
Well, so it was not a situation of armed conflict. So we have to distinguish between what body of law applies to what situation. So if we were in a situation of armed conflict, then you have IHL, LOAC, will apply. So you look into the rules of the law of armed conflict, like Gary said, and that was not the case for the Sony attack. But if a state were in an armed conflict and it was looking at using cyber means, and that proposed cyber operation rose to the level of an in bello attack, which is an IHL threshold, then the targeting rules would kick in. We'd look and see whether the object is a legitimate military objective. We look to the standard set out in Article 52 of AP1, which the United States accepts as customary international law, whether the object by its nature, location, purpose, or use makes an effective contribution to military action. And then second prong, whether the destruction, total or partial, or neutralization of that object at the time and the prevailing circumstances gives you a definite military advantage. I mean, and that's something that Gary and his crowd knows far better than I do, but not a test that we are not unfamiliar with applying. And so there are dual-use objects. Dual use is not an IHL term, but there are dual-use objects all the time that militaries across the world in situations of armed conflict consider under this framework, and I don't think this would be any different. You also have rules that would apply to such attacks that would place limitations on the damage that could be caused. This would be the rule of proportionality, feasible precautions, et cetera. So IHL already takes into account a lot of the concerns I think I heard you expressing with your question. On innocent passage, I think I'd ask you a question back. What problem are you trying to solve by raising that concept? It wasn't clear to me whether what you were suggesting by importing that law of the sea term into this area.
I guess the innocent passage question would be, as Cybercom continues to kind of bring capability to the fleet, in a naval context, we send ships overseas all the time. They're recognizable at a distance. They're military platforms. They're not engaged in military operations, but there were rules of the sea that said, well, you have to conduct your way in certain means when you're doing certain activities. So innocent passage is an example. So when U.S. Cyber Command, as an example, is doing scanning operations, if you are identified and could you say, well, I'm here under innocent passage, I'm transiting through your infrastructure to go do something on the other side?
Well,
I would say that innocent passage occurs every time a government official hits send on an email, and the headers identify that it's coming from a .gov domain. But it comes back to the point that most cyber operations, if not the very smallest number that are intentional, are obfuscated. And so when you think about the balance of where attacks are going, most of the cyber weapons that we're talking about are private sector products, intentional or otherwise. And so if you don't have the right to be able to have a voice in the conversation that balances the equities of how your product or your service, your infrastructure may be weaponized, then it's a very different dialogue. That is the dialogue of the nation state, but it is one that does not necessarily have a transparency and sunlight into what those equities are. So if you are one of those companies that you mentioned, it can be a little bit hard to know what's coming at you.
So there's no such thing as innocent passage in cyberspace. That should be pretty simple. The issue of innocent, because the reason is because transit states have an obligation of due diligence. The question is whether or not it's feasible for them to understand whether or not harmful activities are occurring on their infrastructure as they pass to another state. But forget the concept of innocent passage. It has nothing to do with cyberspace, except the conduct of cyber operations while in the territorial sea of a coastal nation. You, of course, cannot conduct cyber operations that are prejudicial to the interest of the coastal nation. So that's the only place a concept of innocent passage comes in. With regard to your, Jonathan was exactly right. I was thinking the same thing. It's all about armed conflict. If you're in an armed conflict, the one thing, I agree with everything the other panelists have said. The one other issue is, what if you're not one of the belligerents to the conflict? So what if you're a neutral during an armed conflict and your cyber infrastructure is somehow being used by one of the belligerents? There, the law of neutrality kicks in. It's rather complicated. Clearly, if cyber hostilities are being conducted from your territory, then you have to put an end to them. And if you do not, then the belligerent, the aggrieved belligerent, can conduct operations into your state to put an end to them. The question that we struggled with a little bit has to do with the transmission through a neutral state. And we really struggled on that one because there's an old treaty, it's over a century old now, an old treaty that talks about the use of communications infrastructure through a neutral state during an armed conflict. We felt that applied in cyberspace as well, but has an aspect of neutrality. You can't transmit weapons through neutral territory. So the question is, can you send malware through neutral territory? And there the group was split. Very interesting questions.
I think your issue actually does boil down to sovereignty. Because we don't have specific rules in international law, then when you've got one state, let's say, probing private cyber infrastructure in another state, then the first rule of international law we'd look to is sovereignty. And just when we talk about probing, that is not a violation of sovereignty. I think that's pretty uncontroversial. But with regard to the Sony hack, my personal view is that was a violation of US sovereignty. Even though Sony is a private company, but sovereignty protects everything within a state's territory, both governmental assets as well as private. So that was not an okay operation under international law, in my view.
What I think will be exciting is when we start to see equal weight being put towards some of the immunities and protections. You know, what is a digital embassy in the cloud going to look like? And how do we start to draw diplomatic protections from a sovereignty perspective in a logical environment where you've got a virtual machine or a virtual server, or, you know, extrapolate it out. When machine learning is making decisions for the company or for the country, and all of that's happening in a data center outside of the territorial integrity of a sovereign state, what is that going to look like? Digital diplomacy has to start to evolve faster. Digital sovereignty will need to be defined. Digital embassies, data protection, diplomatic protection for data in transit and at rest. All of these concepts are in their absolute nascency, and we're spending a lot more time talking about the use of force and the right to attack, and we're not yet balancing that out with the right to defend and what we're going to hold dear, which becomes really, really challenging when 85% of the critical infrastructure that's relied upon from a cyber perspective is owned by the private sector. So it's not even an instrument of the state. So I think we have to balance out what we're going to be talking about relative to use of force and start to develop diplomatic protections and immunities.
So the Tallinn Manual contains an entire chapter on diplomatic law. And we did find it difficult. And as I mentioned earlier, Jonathan, although we're not attributing, and what you see in the manual is not necessarily the view of the State Department or of Jonathan, it was extraordinarily helpful. But we did find that the law of diplomacy applied, for example, to diplomatic communications by cyber means, for example, to cyber infrastructure in a mission or a consulate or whatever. So we did address that. The other thing I want to foot stomp what Lee said. Sovereignty, the notion of sovereignty, protects private entities as well. It also, of course, gives the state obligations to control the activities of private entities on their territory. So, you know, I guess, again, I'm not that worried about these sorts of things. If we apply the basic concepts, then we, like in diplomacy, if we apply the basic concepts we accept generally to cyberspace, we usually come up with the right answer most of the time, although I hasten to add what everyone else has said here. There are areas where it's gray that will require hard work, but we need to focus on those areas.
All right, opening, again, questions. Yes. Need mic up here. This is what David. David.
My bad. I find it, I've read the Tallinn document one. I'm the opposite. I'm not a fanboy.
Okay, you can sit down now.
But, and I guess the reason for that is when you talk to technical experts, they look at the rule set and they say, very clearly, it's almost like the lady doth protest too much, that international law is extremely relevant in this area and is easy to change and sort of map into the cyber domain. And we talked very briefly about how the definition of what it means to be sovereign has changed and how sovereignty applies. We look at the very first rule in the first Tallinn document, which talks about how states have the ability to control what comes out of their territory and within their territory. And it's very difficult to say that the upper levels of the OSI model map it all to any territory. Anonymity is a key issue on the internet. It devolves the idea of a state-controlled information service to something that is not state-controlled. And we see this with Rule 41 here in the States in domestic issues all the time. But you know, my question is, so much of this discussion is about things which only work when they're covert, right? The NSA and other things. We cannot come to the real world implications of these issues because we cannot discuss the truth about what happened, even in issues that have been publicized, and the majority of the issues, of course, never get publicized. So we're in the same state that we are domestically, where so much of the constitutional law is unable to be viewed, is strictly FISA court stuff, and if we start allowing it to be reviewed, the techniques no longer work. And this is what I see, this barrier toward Tallinn ever being relevant, because when you look at it from an operational perspective, it doesn't reflect any of the technical truths that we know to be useful. So I just thought I'd throw that into the fire.
Correct me if I'm wrong, Mike, but I don't think Tallinn said states can control. It said it may suggest they have a duty to seek to, but not necessarily that they have the capability or capacity to do so. And if they don't, that triggers other implications in international law, right? And your point's very fair, although I think there's a distinction. We see this tension all the time, but there's a distinction between transparency about the rule sets that we will apply and transparency about the facts that we're applying the rule set to. And that's very different, and we have to understand that we can't always be fully open and transparent about the facts that we're applying the rules to for very real security reasons. So I think you have to distinguish between, the process, the rules, and the actual information that goes into the analysis of how you're doing that. And I think certainly Tallinn is transparent. It's not a state document. We've already discussed where you can always look to see whether you can do better. We saw the same question in the counterterrorism area, right? And to being more transparent about the rules and the process that we were applying to making certain decisions. So you got to, I think, separate those out.
Yeah, and just we have made efforts as a government to set out this framework, and what we believe, at least in some areas, is the law that applies. And it's much of the framework that is covered in the Tallinn manuals. If you go to the U.S. Digest of International Law from 2014, the United States submission to the UN group of governmental experts is in there. It addresses in detail the jus ad bellum, the jus in bello. It addresses the law that applies outside of the context of armed conflict and below the threshold of the use of force. Certainly not to the extent that the Tallinn manual does, right? But no state is going to publish a Tallinn manual with respect to all of international law as applied to a particular technology. That's just unrealistic to expect that. But there are those statements out there. I think you should expect more from not only the United States, but other states will be making more statements, just as in the CT use of force context, the United States has. So I think you're right to ask for more of that. I think academics and others who are not in governments are right to be frustrated not to see enough statements about what the existing framework requires of them. But I do think there is more out there than you're giving credit to, and I also think that you question whether that framework will ever be applied. I just go back to a comment I made before. It's being applied on a daily basis, and as Gary said, we may not be able to share the facts that we're applying the law to, but I can assure you that the framework is a framework that gets daily use.
I think the challenge, though, is that the equities conversation still happens within government, and yet the effects of the equities conversation are felt directly by those that own and operate the private sector or that are involved in security, that see the effects of it laying all over the server like a game of Clue with Colonel Mustard and the candlestick. And so as we're trying to think about how we're applying international law and Tallinn, it comes back to I agree and concur that domestic law is not the same domain, but when the discussions that are interpreting international law domestically are not necessarily transparent, or the effects are broader than just exclusively in the military domain, it puts significant pressure on that conversation, and that is still something that you see those that are involved in the private sector very, very much wrestling with.
I'm sorry you're disappointed with our little book. Okay?
But it's still going to cost you $116 to get that.
That's right.
It should be free.
It should be on the internet.
You still have to buy it in order to trash us next time. First of all, I think you're asking too much of the Tallinn Manual, okay? The Tallinn Manual was not an attempt to answer your questions. The Tallinn Manual was an attempt to figure out what the law is and how that might apply. In other words, we were writing that manual, not for you, by the way. I was writing the manual for him. We were writing that manual to provide legal advisors, government legal advisors, not academics, not techies, government legal advisors with a clear delineation of what we believed the law to be and where we saw the gray area so that they could better do their job. So let's take just one of your examples, anonymity. Anonymity is addressed in the manual with some clarity. What we say is, and it's the standard that has been the law for centuries, states are measured by what reasonable states would do in same or similar circumstances. If you get before the ICJ, they will apply their own rules. If you're in arbitration, they'll apply their own rules. But if we're simply asking about the rule is states must act as reasonable states would in same or similar circumstances. So when Colonel Korn is providing advice, he just looks at the evidence like he does with every other legal incident and asks, is it reasonable for me to act based upon the knowledge I have of the actor, given the severity of the consequences I'm going to impose on the actor, and given the severity of the consequences that I am suffering? It's no different than dropping a bomb. Not at all. Now, with regard to state...
Because it's a private sector bomb.
It isn't a private sector bomb. Oh, you mean the one directed against you? Well, I didn't know that was in the facts. If it's a private sector bomb, I can do the legal analysis as well. I assumed it was a state cyber bomb. If it's a private sector bomb, you ask whether or not that operation is attributable to a state as a matter of law. If it is attributable to a state as a matter of law, you have certain options open to you, which were mentioned by my colleagues here. For example, countermeasures. If it is not a state, then you have certain options that are open to you, but they are more restricted. We have to rely upon our domestic law and their domestic law to address the situation. Don't expect international law to answer all your questions. It's not a seamless body of law. Now, with regard to state practice, I want to make this crystal clear. There is confusion about the role of state practice in international law. You need state practice and opinio juris only, the combination of both, only to create a new norm, a new norm. But in the Tallinn Manual, we never, ever tried to create a new norm or suggest a new norm. What we were trying to do was apply existing law. When you are applying existing law, state practice can inform your assessment of the situation, but you don't need it. What you need, and Jonathan correctly pointed to the U.S. statement that was made before the UNGG, the submission to the UNGG in 2014, that's what you need. You need to know, with respect to existing law has applied to cyberspace, whether or not states have agreed. And that's why I think all of us have said we need more of that. But we don't need to see the practice as a matter of law. It would be nice, it would be helpful, but it's not necessary.
I'm getting the axe. I mean, this, you know, you can't get better experts on this whatsoever.